Today we're going to talk about accepting an appointment as trustee. My name is Gregory Singleton. I'm an estate planning and probate attorney with Signature Law. Signature Law is an estate planning and probate law firm located in Minneapolis, Minnesota that serves the Twin Cities and Greater Minnesota alike. Just as a reminder, if you like today's videos, please do hit that subscribe and like button. It really does help support the channel. And before we get going, a couple other caveats. First, these videos are for educational purposes only. And secondly, we're going to be talking about Minnesota law primarily here. So if you live in another jurisdiction, while the law may be similar, do talk with a professional in that jurisdiction before you plow ahead with your estate plan. So, trusts will oftentimes say that they appoint a trustee, but really what they're doing is they're nominating a trustee. If you're nominated as a trustee, you can do one of two things. You can accept it or you can reject it. We're going to talk about both of those things today. First, we're going to talk about accepting a trusteeship. Now, there are three ways to be appointed and to accept being a trustee. First of all, are two ways under the statute, under Minnesota Statute 501C0701. The first thing you can do is very simply follow the terms of the trust. If the trust says you have to fill out 15 pages with your first, middle, last name in reverse order, do exactly that, and thereby you are the trustee. The second thing that you can do under the statute is if the trust does not say that their way of accepting being a trustee is exclusive, or that they just don't put in a way of accepting a trustee, you can do one of three things. First, you can accept the trust property. If the trust property is $100,000 and you accept it, put it into a bank account, and you are appointed trustee, you are thereby the trustee. The second thing you can do is you can just act as a trustee by exercising powers or performing the duties of a trustee. For instance, someone dies, you're the trustee, you can just start with the trust administration, making sure that the insurance on the house is set, etc., thereby constructively accepting being a trustee. The third one is very simply just do anything that denotes that you've accepted being a trustee. Very simple. Just do something that people would accept as you accepting the trusteeship. Now, the former, following the terms of the trust, that's going to be usually when someone is setting up an inter vivos trust or a nested or testamentary trust in a will or a trust. When you're the trustee that is acting kind of like the executor of a trust, you're generally going to follow the second one, the second three methods, which are just to start acting like the trustee when someone dies. Now, the third way of being appointed a trustee and being accepting as a trustee is if a court appoints you as a trustee. Now, this is generally going to happen if nobody is left alive that could be trustee, or for instance, all the other trustees have said no. Then you'd petition the court to be trustee, you become trustee, bada boom, bada bing, there you go. If for rejecting being a trustee, there's several ways of doing it. The first thing you can do is expressly reject being a trustee. You can just say, I'm not a trustee, or better yet, write down, send a letter to the appropriate party, I am not a trustee and I will not accept the position of trusteeship. The second thing you can do under the statute is you can just do nothing. If you know that you are appointed trustee and you you don't do anything for, I don't know what it is, 120 days, 90 days, could be 2 days in an emergency situation, whatever is considered a reasonable time under the circumstances, you will have constructively rejected being the trustee. The third option for rejecting a trustee is kind of the watching yourself and being careful before rejecting or accepting. This is the half and half thing. The first thing you can do when rejecting is you can preserve the property of the trust and still reject, as long as you write send a written rejection to the appropriate party. In this case, take for example, two brothers. Their sole living parent has died. The parent lives in Minneapolis. One brother lives in Minneapolis. They're the primary appointed trustee. The other one lives in, say, San Francisco. Now, the one that lives in Minneapolis does not want to be trustee. However, when their parent dies, they may act to preserve the trust property. They may start the administration. They may do a couple things to say, make sure there's insurance on the house, make sure things are taken care of. That doesn't necessarily mean they are the trustee as long as they send a written rejection to the brother and they've probably, or the other sibling, and they've probably already talked about it at this point and made it clear. But you can work to preserve the trust assets and still reject being a trustee. You don't have to just watch everything go to pot. The second thing you can do, and this is a very important one, whether you intend to reject or accept it, is you can investigate or inspect the trust property. For instance, you can determine if there will be any liability. What if you're going to be successor trustee and the prior trustee, after 5 years of handling a testamentary trust, says, I don't want to do it anymore, you're the successor, go. Well, before you accept that, I recommend you look at the books of the trust. Make sure it hasn't been screwed up. Make sure there hasn't been fraud committed. Make sure that things aren't such a mess that it will be so much work that you're not going to be able to do your job effectively and might get in trouble yourself and incur some liability. Let's look at one last area about this, which is best practices for accepting a trusteeship. Let's start with before accepting a trusteeship. Best practices are: 1, if you're a successor trustee, get a written resignation from the prior trustee. It removes any guesswork about or any opportunity for challenge. 2nd, read the trust document. Before accepting any trusteeship, read the trust document. There could be a non-resignation clause. There could be compensation that you're owed. There could be egregious administration requirements. What if it requires you to do an accounting every week? That's a lot of work. What if there's no successor named in the trust and there's no way for you to name a successor? So if you want to get out, you're going to have to go to court. You may not want that hassle if there's a possibility you're going to want to resign as trustee down sometime in the future. The last best practice before accepting a trusteeship is to inspect the trust assets. As we discussed before, it is allowed under the Minnesota statutes. Take advantage of it. You don't want to walk into a situation that you just don't want to take care of or don't have the capacity to do so. For accepting a trusteeship, generally some best practices. First of all, put it in writing. It's not required all the time, but it just removes all guesswork, and it removes somebody else coming in and say, hey, you never accepted, I'm going to be the trustee, and creating a fight, all that jazz. Don't do it. Of course, best practices are follow the trust requirements. If there is a way of accepting the trustee, but it's not exclusive, probably a better idea just to accept in the manner that the trust designates. Best practices for acceptance form, a written acceptance form for accepting a trustee appointment. Make sure to include the following: your name, the trust name, the date of trust creation and any amendments. Identify the paragraph or the paragraph or section where it says that you will be the one that's to be the trustee that makes the appointment. Make sure that you write in there that you accept it, very simple, and then execute it, sign and date. Also, probably a good idea to notarize it. It's not too hard to do, but it can make a difference if something happens down the road. Best practices for after accepting a trust. First of all, notify the beneficiaries in writing. They probably should know who's going to be writing the next check. And if there is a prior trustee, it makes their life easier and takes a lot of the guesswork out of it. Second of all, take charge. You're responsible now. You're responsible for all those assets. You're responsible for all those distributions. Make sure you take charge and don't just dilly-dally. You are a fiduciary now. You have certain duties and responsibilities. So there you have it. That is my take on accepting an appointment of trustee. I hope you liked today's video. If you did like today's video, please feel free to smash that like and subscribe button. It does help support the channel. Also, if you did like this video, we do a new video every other Wednesday, so look forward to that. If you have any questions, leave them in the comments below, or just send me an email, always appreciated. Other than that, until next time, this is Gregory Singleton with Signature Law.